Well, good morning to 4CRB's The Law and You. My name is Alex Wynn. I'm with the Bell Legal Group, a solicitor there, and I'm standing in for John Fradgley this morning. So if you have any questions concerning the law, I'd especially like them on family law, which is my area of expertise, then please give us a call on the usual number, 55208888. Now, I can see that we've got a call waiting from a lady called Shirley. So, good morning, Shirley.
Oh.
Hello?
Yes.
Hello, Shirley. It's Alex Wynn here from Bell Legal Group's 4CRB presenter today for John Fradgley in his absence. And I gather you have a question for us.
Yes, well, I have a problem with my neighbour is smoking these vapours, and I'm getting all the vapours and all the odours filtering into my house, even though I've got my doors and windows closed.
Right.
And I just don't know where to turn to get help. I've tried the council, and they advised me to have a chat with them, but you can't talk to them because they won't open their door and they don't answer their phone.
Okay, so you've attempted to talk to the people that are smoking these vapours and
yes,
getting no response at all from them.
I can't get any cooperation. I've written them notes as well.
Have they ever replied to you at all, Shirley?
Well, one of the notes they did, but it was before I knew what the odour was, and he told me it was my drains or it was my health and all this thing. Then I've found out since that we just happened to be cutting down a tree, and she came out and said that he was smoking these vapours.
I see.
And I've heard that they're not really very healthy for you.
Well, I don't think it's healthy to smoke many things these days, is
it? It's not.
It sounds to me very much as if what you're dealing with there is what's called a private nuisance in terms of the law. The council really ought to step up a little bit more for you there. Who have you spoken to? Is it a Gold Coast City Council?
I just spoke to one of the girls. Mediation that they suggested, and then I did ring the mediation people, and they sent me the papers, and I knew it wouldn't work, but I thought, no, I'll just try it. So I wrote them a little note, and I put the papers in their letterbox, and just said, would you like to, if you'd like to check it, but no, they wouldn't do anything about that.
So that was to your neighbours, you mean, that you left the paper?
That's my neighbour, the neighbour that's using these vapours. And they're up all night. They don't sleep at night, so I don't get any sleep at all, and it's just getting to me. Okay.
You obviously need to address this because it's going to upset you and it's going to make life very difficult for you.
Well, it is very difficult. This has been going on for 5 months, and it's affecting my eyes and my mouth and my throat. So I didn't know what to do. Are you on the Gold
Coast, Shirley?
Yes.
Yeah. And you really do need to get onto the Gold Coast City Council. They have environmental protection officers that would be able to assist you. Perhaps if you could contact them, I can let you have their number at the end of this call.
That would be great.
The idea would be that you need to report to them so that if your neighbour is ignoring you, there's not going to be an awful lot of point of you continuing to leave notes for them or if they're not answering the doors. But they'll have to pay attention when the council become involved because it becomes more of a public matter.
Well, I need somebody with authority to help me.
Well, it sounds very much like the Gold Coast City Council's environmental protection officers would be in a position to give you some assistance with that. I'm just looking through. John's very kindly left me his notes here. With the Gold Coast City Council. I'll get that number for you and I'll put it out before the end of the show, if I may, Shirley, for you to give them a call in the first instance. You do have, if the Gold Coast City Council reach a blank with that, and I hope that they won't, but you always have the ability to, I hesitate to say it, but take your neighbours to court in relation to a private nuisance matter like that and obtain orders from the court. But your first port of call, if you can't resolve things with your neighbours amicably, and they're ignoring you, so that doesn't sound very likely, is to use the local authority because they have got the legislative power to deal with that and to make orders and to compel those people to stop causing a nuisance for you so that you can get some sleep and your throat gets better. If I
just rang and asked for the environmental department, I could get on to them.
If you call the Gold Coast City Council and ask to speak to their environmental protection officers.
All right, then I'll do that.
And explain that's to do with a nuisance from the neighbouring property, and go there in the first place.
Oh, thank you so much for that.
That's all right.
Well, I'll do that. So don't you worry about ringing back. Thank you so much.
Take care now, Shirley.
Yes,
Goodbye.
Yes, bye.
Well, if anybody else has some legal queries for us, this is Alex Wynn of the Bell Legal Group, standing in for John Fradgley this morning on the 7th of May. I noticed as I was coming into the radio station this morning that the news headlines are flooded now with Meghan and Harry having their child, and I don't want to be a spoiler, but if you haven't heard, it's a baby boy. That now means the newspapers and the television will be full of talk of the succession and of the name of the child, and that sort of leads me sometimes into some of the areas that I deal with as a family lawyer, which is who gets to choose the name of a child. Now, in family law, of course, that's the situation that arises when a mum and a dad perhaps aren't getting on terribly well. And you might agree with the name of the child when the child's born, but what happens then later on if you separate and you want to change the surname typically of a child so that it's got mum's original surname in or dad's name in? And the answer is unique to every situation. The guiding light as far as any court orders would be concerned would be, is it in the best interests of the child? So if a name is going to be something slightly ridiculous, it's not going to be allowed by the Department of Births, Marriages and Deaths, certainly. But you can always arrange for an application to be made to change a child's name if later on that becomes appropriate. Now, we haven't got any calls waiting right now, so I thought what I might do is to have a look through some of John's notes and see what inquiries we've received historically, so that I might comment on those from a family lawyer's point of view. One of the questions that pops up on a fairly regular basis is where a mum and dad lend their son or their daughter some money early on in that child's relationship, perhaps to put towards a deposit of a house or something like that, and later on the couple split up. And what is to happen to that money? The answer will always come down to how well have you documented it and how much have you really been expecting to be repaid. Look, I'll touch on that a little bit later. I can see we've got a lady waiting, Erica, with an inquiry. Erica, good morning. Alex Wynn, how can I help you?
Thank you, Alex. I'm ringing about a young woman who's got a kid that's now 12 years old. He's never met his father, obviously. Mm-hmm. The couple broke up while she was pregnant.
Right.
Now the young woman is seeing the guy's mother, so the grandmother.
Right, so the mother is seeing the paternal grandmother.
Correct.
Yes,
now,
okay.
The guy's, the fact that he's a father is not on the birth certificate, although it wouldn't be hard to prove it, I suppose.
Mm-hmm. Yeah. DNA evidence these days is very easily obtained. That's right.
Yes. So, what rights has he got, and what rights has the grandmother got?
In terms of seeing the 12-year-old boy?
Well, in terms of, taking the kid off the mother.
I think that would be extremely difficult unless there are some real risks of harm to the child. Erica, I don't know anything, of course, about the background to this matter, but what you would have to bear in mind if the child has always been raised by the mother and the father's had nothing to do with the child, then at 12 years of age, it's very difficult to suddenly change those arrangements. I'm not saying it would not happen, but it would need to be a very graduated introduction of the father into the child's life, and equally the grandmother as well. And that's because, as I was talking briefly a moment ago about changing names, the overarching legal consideration when you're making any change of arrangements for children is what is in the best interests of that particular child. Now, if the child doesn't know the father, doesn't know the paternal grandmother, it may be quite a shock for that child to suddenly be spending a lot of time with them. And that therefore needs to be introduced very steadily and make sure that it's in the child's best interests for them to spend time with the father. Grandparents are dealt with specifically under the Family Law Act as well, so that the grandmother could also seek time to spend with her grandson, and the same considerations would really apply. So if the father is a fellow who is keen and motivated to spend time with his son, if the grandmother similarly would like very much to see her grandson, then the first thing I would suggest that they do is to talk to the mother about it. The mother and the father, as a matter of law, would have equal shared parental responsibility, but the father in this case doesn't appear on the birth certificate, so he's got a bit of a hurdle to overcome there. In a practical sense, they should be trying to talk to the mother first.
He's a scoundrel.
The father's a scoundrel, okay. Well, that might make things a little bit more difficult for him then, because if he's a scoundrel, you don't necessarily want to introduce that person into the child's life if they're doing well otherwise. But having said that, somebody who's a scoundrel doesn't necessarily cease to have the capacity to be a parent that loves the child and for the child to love that person. But if the child doesn't know who they are at this stage, it'd be very hard, I would think, for the father to be able to obtain orders for the boy to spend time with him. Might be a different kettle of fish for the grandmother, though. As I was saying, the grandparents in Australia are regarded as one of the people who can apply for what are called parenting orders. And that doesn't mean that the grandmother would suddenly look after the child. It just means that you have the ability to ask the court to be able to spend some time with the child, a few hours at a weekend perhaps. But
even
again,
though it's not proven on DNA.
Well, the DNA could be an issue. If the father, who's a scoundrel, doesn't want to provide his DNA sample, then that could cause a problem for his mother if she wishes to pursue grandparenting orders effectively. But it's not just about the DNA. The DNA could always be ordered if that became an issue. What does the grandmother and the mother? I mean, do they get on at all? Are they amicable?
Oh, they're starting to have a relationship.
Well, I think that's the best way to proceed in this type of case, Erica, is to try and keep it out of the courts wherever you can. Talking to the other person and saying that you'd like to, for the grandmother to say that she would like to spend some time with the grandson and to get to know him a little bit. And to do things on a very much a baby steps, tiny little steps towards spending that time with the grandson. And not worrying perhaps too much about the father, who may or may not come into the picture at some stage. But if the father were to come into the picture, it would have to be in such a way that the son wasn't affected by it, the grandson, that is. You can't just jump straight into court and ask for orders, of course, in these things. You have to try to resolve the parenting issues yourself first. So the grandmother, even if the mother has refused and she's still very keen to spend time with the grandson, to the point of saying, OK, well, I will ask the court for that permission, you would still need to go through what's called a family dispute resolution process.
Right.
And Relationships Australia and organisations like that can help enormously in trying to bring people together in the first place to see whether or not the intervention of a third-party expert family mediator might be able to make the mother say, yes, OK, well, we can move towards spending time. But if the grandmother and the mother are already talking, then I think that's a really good and a positive sign. I can pass on the details for Relationships Australia if you need them. But in the first instance, probably the mother should be talking to the grandmother and hopefully have some family time in the future with the grandson.
Yeah.
There's no quick answer, I'm afraid. It would, the father and his DNA, that's a complication, but it's not exclusively determinative. So if there is a relationship and the mother acknowledges that the child is, that the child is the son of the scoundrel father, then that's not probably going to be so important because both parties agree who the father is and who the paternal grandmother is. Does that help at all?
And it's the same interstate? She's interstate?
Oh, yes. In fact, if it's across Australia, we have in that area of family law, the same Family Law Act applies throughout the whole of the country, no matter which state that you're in or territory. So the same considerations would apply. That's right.
Thank you.
Thanks very much, Erica. Thanks for your call. And if anybody else has any calls or inquiries for The Law and You, this is Alex Wynn of Bell Legal Group, standing in this week for John Fradgley. I can't see there's any calls here right now, so I'll go back to that question about loans from parents to their children and then what happens to those loans in the event that the children later on separate. I've been on both sides of those cases in the past, and there is no straightforward answer because, of course, it's family law. If you want to get an opinion of 12 different lawyers, you'll get 12 different opinions. But the cases tend to suggest that where there's no genuine expectation that the money is going to be repaid back, even if there are some documentation talking about the loan, the probability is that that loan will not need to be repaid by the parties who have separated. Really, it'll be stuck with the child. So if you lend your son some money and then some years later they separate from their partner, the partner, I think, would be legitimately able or likely to be able to claim that money's never properly repayable and it was more by way of a gift. And that tends to be the case with those matters. So if you are considering lending your child some money and you genuinely expect to get it repaid later on, go and see your solicitor and get it documented, and then ensure that you don't just have a paper arrangement. There needs to be real transactions as well. So just having a loan document, as I experienced quite recently, having a loan document that could be 20 years old, where nobody's ever made a payment under it and it's never really been expected, a court is not going to be persuaded that that loan is really repayable. So if you're going to lend money, get the loan documents drawn up and make sure that it's actually kept up to date as the years go by. Okay, I was looking through some of John's old queries that he's received in terms of family law, and one of them is about making a divorce application. And how is that done these days? Well, it's an awfully lot more straightforward procedure than it used to be. I mean, if we go back to 1975, for those of us who can remember that time, and you probably pick up from the accent that I wasn't in this country at the time, but I've been here a long time now. The laws in Australia changed so that there is no fault in relation to divorce these days. You don't have to have little men in their Macintoshes hiding in motel wardrobes with their cameras. That's not necessary anymore. The only criteria in terms of being able to apply for a divorce in Australia is that you have been married for more than 2 years and that you have been separated for more than 1 year and that the marriage has broken down irretrievably. Now, the no-fault divorce process is obviously it's a much better and more comfortable arrangement to avoid any unpleasantness that goes with proving perhaps people's different perspectives upon morality. But it does make for a very straightforward process now. So if that relationship has ended, you very often won't even need to step foot inside a courtroom these days. We live in an electronic age where the internet is extremely present in all of our lives, and that's to the point of divorce applications as well. We do most of these things online these days, and if there are no children under the age of 18, then people won't even have to do much more than filing the documents online, paying a fairly hefty filing fee, I'm afraid. It's about $900 to apply. That's just the court fee. If you engage solicitors, of course, they'll have their own costs for that as well. But it's a very straightforward process these days. It takes a little bit of time because there's quite a few applications made and not that many registrars at the court to deal with them, so they could have many hundreds of these things going in. But there we are. Now I can see that Erica's back online, so I will just return to her briefly. Good morning, Erica.
Yes, a completely different question
about
that.
That's all right. Thank you for calling back.
Same unfortunate girl, and I think you were just answering the question I had, so I'll, right. So this young woman who got herself pregnant and the kid never saw the father.
Yep.
Well, 3.5 years ago she got married to a completely different bloke.
Yep.
And kicked him out after 10 months. And, he was a no-hoper.
Right.
I'd say she is too. And now, she's not bothering to divorce the first fellow. But what if she comes into, say, a heap of money?
Well, they're both kind of on the hook to each other as far as that goes. It's a great question, Erica. I'll finish off what I was saying about the divorce process because that has a bearing upon it. These days, as I say, it's almost exclusively an online application that you would make for divorce. There is a child in that case who's under 18, so it may be that the mum would need to go to court depending upon whether the ex-partner would be prepared to join in the application or not. And that's only so that whoever is the person that's deciding the application, they're called registrars, so that the registrar can be comfortable that the arrangements made for the child are appropriate. But going back then to your financial element to that question, it would be in the mother's best interest, I would suggest, to make the application for divorce sooner rather than later. And that's because whilst they remain married, either of them can always make an application to the court for a property settlement. And if one of you comes into money, a lotto win or an inheritance or something like that, then you may very well suddenly find your ex-partner popping up on the scenery with their hand out. And they might make that application to court, and they would be entitled to make the application under Section 79 of the Family Law Act. They wouldn't necessarily get too far with it if they can't persuade the court that the contributions have been made in relation to that property. But it has been known there are decided cases where people have been separated for some years, and still the ex-partner comes back when they hear of the money, and they are able to achieve a property settlement. Making the divorce, however, making the application for divorce now, would start the clock ticking as far as a limitation period goes. Once you have been divorced and the order takes effect, and if you were to file an application today, I imagine, where are we, the 7th of May, you'd probably be looking at a hearing date perhaps in August, and then it's 1 month from the date of the hearing for the divorce to become effective. Then it's 12 months from that date that you've got to bring a property application if you're going to. And if you don't bring your property application within 12 months of the divorce becoming effective, then you lose your automatic right to apply. And you would then have to obtain special permission from the courts. So an application before you're allowed to make the application, if you like, before you're actually allowed to do that. And that can be quite an expensive and fruitless process if you haven't got good grounds for it. So it's a very good question, and I think the answer is make the application for divorce so that you can get that time period ticking and get over that 12 months before the lottery or the inheritance arrives and causes a complication with the second scoundrel. Okay. Thanks very much for the call, Erica.
Thank you.
I see we've got another call, a lady called Maureen. Good morning, Maureen. Alex Wynn of Bell Legal Group standing in for John Fradgley. How can I help you?
Hi, Alex. Alex, is it?
Alex, that's right.
Oh, hi, Alex.
Morning.
If someone represents themselves in the family court for 3 years,
Yep.
Okay, and then finally there's the final orders,
Yep.
and he still represents himself,
Yep.
and it isn't, he's against, the other side had a QC,
Yep.
all right? Now, he did everything that he was supposed to do, but it was really difficult.
Yeah.
Okay, and we still are waiting on the judge's final orders.
Right, so they reserve their judgment, I see.
Yes, all right. Okay, now, if it doesn't turn out, reasonably,
Yes.
is there a law to say that he can go back to court? Someone told us that when you self-represent, there is something that says you can go back and try again.
No, not as of right. The law applies the same whether you're represented or whether you're not represented, Maureen. What, however, they may have been referring to is that if a decision is handed down by the judge, and I understand a lot of times you have your trial and the judges will reserve their decisions whilst they consider it and work through, then what happens is you could have an appeal. The appeal would be on the basis of the law, and so my suggestion would be if the decision is handed down and it's adverse, it's not something that the self-represented person wanted, they should, in my view, go and get urgent legal advice from a specialist family lawyer to consider whether there are grounds for an appeal, and you'd need to do that pretty quickly. You've got 28 days in which to lodge the appeal.
And what about, Alex, if the ICL, the independent children's lawyer, did not do their job properly?
That can be very difficult to establish. The ICLs are generally very hard-pressed, hard-working individuals, but I recognise that every case is different.
Well, do you want me to tell you what happened?
Yeah, by all means. But you can't identify anybody, though. I just have to say that.
No, I won't identify anybody, all right, but they are appointed by the court.
Yes.
The original judge.
They are.
Okay. However, all documents and affidavits had to be put in prior to the court, all right,
yep.
which was done. And it was...
Maureen, I'll have to interject just briefly and say, we'll carry on this call off air if we may. I see we've reached the end of 9:30 in John's show. So,
I understand, Alex.
We'll be off air, but we'll carry on talking. Okay.
All right, fine. Thank you
hold
for
on
that.
For that. Thanks, Maureen.
Hold on.
Thank you.
Okay, bye-bye.
Bye-bye. Well, thanks everybody for phoning, to Shirley and to Erica and to Maureen, and I hope you found some of these topics interesting. Thank you very much to John for letting me stand in his shoes today, and I look forward to talking to you again on The Law and You.